Senate Bill 46.
We have an amendment, Mr. Chairman. Thank you. While
We do have some amendments. Senator Gatti, why don't you talk about it real quick? We'll go ahead and start passing those out while you're talking about them.
initially the bill was geared towards excluding a group of people from being charged with this crime, and those people would have been people who are otherwise eligible to carry a gun, but they have not taken the class yet. After some discussion with the stakeholders in this, that would confuse the reciprocity that we have with our concealed carry laws. And so kind of went back to the drawing board over the last month or so and spoke with some of those stakeholders and working with Senate staff to come together with an amendment that would help the concerns or kind of quash the concerns of reciprocity issues, but also have some clarity in the law. And actually we came up with a unique situation. Instead of talking about the class of people that would be excluded, we would talk about how the sentence would be carried out for these people that are otherwise legally able to carry a gun. And what this amendment does is it takes away some of the confusion of the bill, and it adds the following, and it just says, if a Louisiana resident is arrested or issued a ticket under this section, which is the section of illegal carrying of weapons, he shall be granted 6 months from the date of his first hearing to obtain a concealed handgun permit. This is really similar to what happens if you get pulled over and you don't have your driver's license, or your driver's license is suspended. Typically a judge will either sentence you or he'll give you a few months, a few days to get a driver's license. And if you get your driver's license, ultimately the charge is dismissed or dropped down. So in this situation, the person would be given 6 months from the date of his first hearing to obtain a concealed handgun permit. And what that means is that he would have to not just take the class, he would have to go through.
And let me go ahead and, while you're explaining this, members, you have an amendment in front of you, 2798, that Senator Gatti is discussing, that he would like to put his bill in the proper form to speak about it. Senator Chavez is going to offer that up. Do we have any discussion, any objection? Hearing none, that amendment will be adopted. Now, if you want to go ahead and discuss your bill as it sits with the amendment on it.
And so basically what this bill would do is if someone has written a ticket with a concealed gun without a permit, on their first offense, the judge would allow them 6 months to not just take the class, not just sit in on the class, but to get their concealed carry permit. And if they do that, then their first charge would be dismissed.
Now, if I'm understanding correctly, they have to be eligible for a concealed handgun permit when they get issued the citation, or when they're arrested. They have to not be in the commission of a crime. So basically, the only crime that they're committing is that they have a concealed handgun, but yet they were eligible to have one. They just didn't go take the class. So you're saying, hey, go take the class, and if you qualify, pass the class, then we're going to drop the charges. If you don't do it, though, then you're ineligible for the future, and the citation stands.
Correct. And so if someone gets a ticket, they go to court, the judge says, well, you have to go get your concealed carry permit. If they show up at the class and they do the background check and say, look, you've got 17 felonies on your record, well, then they're not eligible to get a concealed carry permit, and so they would have the charge of illegal carrying of a weapon. And of course, that's a hypothetical. Technically, that would be determined at the first hearing, running a background check for the charge. Okay. We have spoke with the state police and the Sheriff's Association. These amendments, the amendment to change the amendment to allow 6 months was something that I brought up. Their amendments are listed in what's the new section B on line 21 of the amendment, and it specifically goes to your concern, Mr. Chairman, which is the arrest is not in conjunction with any charge on the same date or time. So if there's any other crime that's being committed, then this would not be applicable. And then it also lists the other
All right.
other crimes that are listed in the original bill that show that you can't be if you have a history of domestic violence, this wouldn't apply to you. If all those other laws that are out there that say you can't have a gun in this place,
You have to be eligible.
you have to be completely eligible.
Senator Torver for a question.
You're saying that if this man get a ticket for carrying a concealed weapon, that he can go to school to go through the qualifications, whatever it may be, go to target practice and everything, and get approved. Then they go and drop the charges, right?
If he passes all of the requirements of the concealed carry laws, which is the background check, target practice, all of those other things that you mentioned, then yes, he could go back and have the charge dropped. But if he doesn't do that in the time period, he's going to have this charge on his record.
But this guy knew at first you had to have a concealed weapon permit to carry a gun.
Correct.
Why would he carry a gun without a concealed weapon permit? Because
Well, I mean-
he's 21?
Well, I think where this would come up, it would be purely by accident.
Oh, by accident.
Yeah.
Oh, by accident. You're saying this 21-year-old, very mature young man, by accident got a gun on, and he wanted, by accident, he got a concealed weapon.
Well, in our neck of the woods, a lot of people carry a pistol with them to
Well, I
shoot.
don't know what neck of the woods you're from.
Caddo Parish, Bossier
Well,
Parish.
Cattle Parish, they don't do things like that.
Well, up in the northern part of the parish.
Well, they might do it somewhere. But he knew he was in what I'm saying to you, he was very clear he was in violation of the law.
No doubt he's in violation of the law. No doubt.
So
That's
we're
why.
going to let him go through all the necessary things and slap him on the wrist and say, hey, since you went through all of these, went through the qualifications and everything, we're going to drop the charges. Now, this ain't like, without a license. It ain't like without a driver's license. This is a gun that could kill people. But it's concealed. And you want to just say, we'll forgive that.
Well, it would have to be in a situation, the way the law is written, that there's no commission of any other crime at the same time. We have drafted this in such a way that it would only apply to someone who is otherwise legally able to carry this gun, but they have not taken
Do
the
you
class.
have someone in mind?
Not necessarily,
Well,
but it does happen, and there's a fear in our community of, somebody's out bush
here
hogging.
in our community that a 21-year-old boy even got a concealed weapon. That's a fear.
Well, and that doesn't deal with that, because if
Of course,
he,
not a fear for me because I'm an undertaker,
Oh my goodness. Well, our concern is that a lot of folks have taken the concealed carry class. They enjoy that class. Sometimes people don't have the time to take that class, and these are business owners, farmers, people that work 6 or 7 days a week. And if they happen to be in a situation where they sit on the board of a corporation, if they're a dentist, a doctor, an undertaker, or anybody that is licensed by the state, they would have to report this arrest to their governing body. And then they're sitting there saying that they may receive a draconian type punishment for having a misdemeanor on them. And those are the folks that I would be concerned about with this bill. However, if they're licensed by a state board, if they sit on a corporate board, and they happen to have their pistol in their pocket and they haven't taken their class yet, and something were to happen and they were to get this ticket, then this law would provide that they would have to take the class and be eligible within 6 months. And if they don't do that, then they were guilty of it, and they'd have to report it to whatever the dental board or the bar association or whatever board they're a part of, and then they would, the chips would fall where they may. This just allows a little bit of a buffer for these guys. It doesn't exonerate them, because it's and they can only do it one time. If they go take the class and they do it, then they have to pay their yearly permits. They're part of the system that we want them to be a part of.
Okay.
And but I'll mention just on the record, I've talked with the Sheriff's Association and the state police, and And although we've been working on some language and we've added some of their language, I've promised them that I'd said on the record that if that they still want some time to digest this bill and the right, because you don't want to upset the apple cart, because we have a lot of people taking this class, and we sure don't want people to think they don't have to take the class now, like you're saying. So I have told the Sheriff's Association that we give them additional time, that I won't have the bill even heard on the Senate floor until they've had plenty of time to look at this and talk again with the DAs and talk again, because we have made a significant amendment to the bill today. But the reason to bring it for the committee today is we're kind of running out of time. So, but I appreciate your questions, Senator Tarver.
Thank you, Senator Tarver. We don't have any more questions on the board. We do have some other cards. We have a card who's present would provide information if requested from Captain Greg Graffa from State Police. We do have some cards in opposition and one wishing to speak. Angel Bradford, would you come on up? There you go, with Moms Demanding Action. We have two other cards in opposition not wishing to speak. Kevin Hayes with the Association of Chiefs of Police and Ryan Haney with Every Town for Gun Safety. Thank you, Ms. Bradford. State your name for the record, please.
Yeah,
proceed.
my name is Angel Bradford. I'm sorry I left my glasses in the car, so this is going to be very interesting. But good morning, and thank you for letting me speak. I'm a student, graduate student at Southern University, and I work with Moms Demand Action as a volunteer. We are a grassroots movement of Americans fighting for public safety measures that respect the Second Amendment while protecting us from gun violence. Moms consist of about 3.5 million members, and we're part of Every Town for Gun Safety, the largest gun violence prevention organization in the country. I'm here to urge you today to vote against a dangerous bill that would let people carry hidden loaded guns on crowded city streets, in parks around children, and in other sensitive public areas with no permit and no training. Even with amendments, this law would embolden people to carry guns without permit and circumvent punishment. Louisiana's moms oppose this bill because they dismantle a crucial public safety law. Permits ensure core public safety standards are preserved when people carry concealed handguns in public places. For example, permits make sure that individuals have undergone firearm safety training. In Louisiana, this includes live fire training, making sure people have actually handled a handgun before they carry a hidden one in public. This bill would also open the door for dangerous people, including some violent criminals, and those with a history of alcohol abuse, to legally carry hidden loaded guns in public. Under current Louisiana law, people who have been convicted of a misdemeanor crime of violence cannot obtain a permit to carry a concealed handgun unless 5 years have elapsed since the completion of their sentence. Under this bill, these violent criminals would be legally allowed to carry concealed handguns in public immediately. Louisiana law also prohibits people who chronically and habitually abuse alcohol from getting a permit to carry a concealed handgun. Under this bill, chronic alcoholic abusers would be able to carry concealed guns in public. Law enforcement opposes this bill as well, and we stand with them in their opposition. I worry about keeping Louisiana families safe. Our permitting system is a crucial public safety law that helps to do just that. This bill would put our families at risk, and I urge you to vote against this dangerous proposal.
Thank you, Ms. Bradford. We do have a question from Senator Peterson.
Thank you, Mr. Chairman, and thank you, Senator Gatti. Certainly have a little bit of an appreciation for what you're trying to do. And your name again?
Angel Bradford, yeah.
Right. Thank you for being here and being active with 3.5 million moms across the United States, and offering your advocacy. You bring some very salient points, and duly noted. I just want to say thank you and good luck in your studies.
Oh, thank you.
Thank you, and thank you for coming and testifying and taking time out. It's important that you're part of the process, and good luck with your education as well.
Thank you so much.
Thank you. There are no more questions, no more cards. Senator Gatti to close.
Thank you, Mr. Chairman, and as the young lady just mentioned, I mean that's those concerns are why we made some big amendments to the bill, because the person has to the only way the person would benefit from the 6-month period to take the class is if they were eligible at the time the arrest happened, which means no domestic abuse battery in their past, no habitual intemperance. I mean, whatever the requirements are to have the concealed carry permit would have had to have been active on the day that they were arrested. And so this bill is narrowly tailored to encourage public safety and to give those folks that haven't had time to take the class, if that rare instance happens where they are arrested or given a misdemeanor, that they will have a way and a deadline to get it done. And once again, if they don't pass the class, if they don't pass the background check, if they don't jump through all the hoops that are required under our very smart and well-written concealed carry law, then they will not get the benefit of having this charge dropped. So we appreciate the committee's time, and I thank you for allowing me to have this bill come before you today.
Thank you, Senator Gatti. Member Senator Gatti is closed on Senate Bill 46. We have Senator Peterson for a motion.
Thank you, Mr. Chairman. Senator Gatti, thank you, but basically listening not only to that opposition, but just having some similar concerns before even hearing any of the testimony by Ms. Bradford. I am concerned about opening this up any further. I think that the current laws provide for an ample opportunity for people to exercise their Second Amendment rights and to carry weapons and concealed weapons. And I think this goes a little bit too far. So with that, I respectfully disagree and move that we involuntarily defer the bill.
Members, we have a motion in front of us by Senator Peterson to defer Senate Bill 46. We have any discussion? We have any objection? We have objection from Senator Chabert. So, members, when Madam Secretary calls the roll, if you are in favor of deferring, vote yea. If you are opposed to deferring, vote nay.
Senator Chabert votes nay. Senator Morrell votes yea. Senator Peterson votes yea. Senator Tarver votes yea. 3 yeas and 1 nay.
Thank you, Madam Secretary. Members, by a vote of 3 yeas and 1 nay, the motion to defer carries. Thank you, Senator Gatti.
Thank you, Mr. Chairman. Thank you, members of the committee.